Ready? Start. Further, what is relevant to notice is that it was stipulated by this court that if the appellant failed to do so, it was always open to the respondent number one to take necessary steps to safeguard the interest, which included inter alia the consideration of other offers made by other parties. Such weighty observations would not have been made by this court if this court in the said matter had come to the conclusion that there was a concluded contract of sale between the appellant and the respondent number one. As this court has come to the conclusion that there was no concluded contract of sale of the mortgage property in favor the appellant of by the respondent number one, the question arises as to whether the right to redeem the mortgage property conferred by Section 60 of the Transfer of Property Act upon the mortgagor, that is respondent number 3, can be exercised or not. It is argued on behalf of the appellant that both the High Court of Bombay as well as this court in the previous round of litigation had found that upon continued default on the part of respondent number 3 in making payment of amount of loan, its properties mortgaged with respondent number 1 were attached and possession thereof was taken over legally in an action under Section 29 of the State Financial Corporation Act 1951. The learned counsel for the appellant contended that the respondent number 3 had never sought to exercise its right to redeem the mortgaged property before action under Section 29 of the State Financial Corporation Act 1951 was taken, or even thereafter till it lost up to this court on August 24, 2006, when special leave petition number 4957 of 2006 was dismissed, and therefore the exercise of right to redeem was not only malified but also to defeat the judgment of this court. According to the learned counsel for the appellant, the first proviso to Section 60 of the Transfer of Property Act 1882 applies with great vigor to the facts of the case, clearly disentitling the respondent number 1 to apply for redemption of mortgage properties on August 25, 2006 or thereafter, and said right of redemption stood foreclosed both by the acts of the parties and by a decree of the court. What was stressed was that non-execution of conveyance deed by the respondent number 1 in favor of the appellant was illegal, and thus the respondent number 1 was stopped from taking advantage of its own wrong. In the present case, the respondents in the writ petition had raised a specific plea of delay as a bar to grant relief to the petitioners. In our view, it was perhaps necessary for the court to have specifically dealt with this issue. It is now well settled that a person who seeks the intervention of the High Court under Article 226 should give a satisfactory explanation of his failure to assert his claim at an earlier date. The excuse for procrastination should find a place in the petition filed before the court, and the facts relied upon by him should be set out clearly in the body of the petition. An excuse that he was agitating his claims before authorities by making repeated representations would not be satisfactory explanation for condoning the inordinate delay in approaching the court. If a litigant runs after a remedy not provided in the statute it cannot be a satisfactory explanation for condoning the delay in approaching the court. On this issue, we have heard the learned counsel for the parties in great detail, since the immovable properties right of the parties are involved. In our considered view, there is no explanation, much less satisfactory explanation, offered by the respondents in approaching the writ court after an inordinate delay of nearly 15 years from the date of the notification issued under the Evacuee Property Act. For the delay from 1952 to 1955, the contesting respondents would only submit that they were not aware of the notification issued under the Evacuee Property Act, since no notice was served on them, though a public notice was issued by the authority under the Evacuee Property Act. While explaining the delay of nearly 11 years from 1955 to 1966, they contend that they were in possession of the property and they were making representations before the authorities under the Evacuee Property Act for redressal of their grievance. The delay after the orders were passed by the Settlement Commissioner in the year 1983 till the writ petition was filed in the year 1990, it is explained that they had moved the state government suo motu to revise the order passed by the Chief Settlement Commissioner, and since the state government returned their request, they had approached the High Court to issue directions to the state government to issue appropriate directions. Source 3P Legal rhc1 exercise number 5. वर्ड्स है 805. स्पीड है 112.